Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is for the law taught students, particularly we are discussing the Consumer Protection Act. Right. So today we are dealing with the incidents relating the late running of trains. Late running of trains. I am going to give you a negative example as well as a positive example also. Negative example, this is case law. Union of India versus Ashok Kumar Singh, 1995. So Ashok Kumar Singh is a reputed lawyer. So he has booked a ticket, first class ticket from Saharsa, Udaipur on some date. Please remember, previously 6 months advance time was given for reservation of your tickets. Nowadays I think it is only 4 months, 120 days. Previously 180 days time was there. You can book tickets leisurely and enjoy. But please remember, the railways, definitely they will be changing the times normally during the month of April, May or things like that. His journey was on maybe 22/6/1990. But please remember, the railway changed its timings from 1/5/1990. 1 month advance. In 1 month advance, the railways, they have made a publicity. They have clearly, it has come in the press also. At the time, TVs were there, but we are not only, we see the TV only for Vividh Bharati or some Chitrahar and news. That's all, Doordarshan news. So definitely they have published in press, they used to publish. But our advocate might have forgotten to look into the papers because he was busy with legal profession. Whatever it is, on 1/5/1990, as per the scheduled time, he went to the train, but already the train has gone away because it was advanced. You see the fact. Now what happened? Actually, he was under the impression that since he purchased the ticket, the train would be on time. So normally there are occasions where you may not be bothering about the train timings also. ఒక అడ్వకేట్కి ట్రైన్స్ ముందు వచ్చినాయి వెనకొచ్చినా తెలుసుకోవాల్సినటువంటి ఆ బాధ్యత కూడా ఉండకపోవచ్చును. బట్ వాట్ ఎవర్ ఇట్ ఈస్, సో దట్స్ వై అడ్వకేట్ ఈజ్ ఎ సోషల్ ఇంజనీర్. సోషల్ ఇంజనీరింగ్ అంటే సమాజంలో జరిగే సంఘటనలన్నీ మనకు తెలియాలి, దాని మీద మనం రియాక్ట్ కావాలి. దట్స్ వై during the time of independence struggle, overall the people that came forward for the independence of India, Mahatma Gandhi advocate, Nehru advocate, so many people are there, all advocates. So that's why I point it out to you that advocate is a social engineer. And normally, even as a general person, as a man of ordinary prudence, do you mean to say that, don't you know the railway timings? సో నార్మల్గా తెలిసిన తర్వాత, అరే మన ట్రైన్ టైం అట్లీస్ట్ యూ కెన్ లిక్ టు ది పర్టికులర్ ట్రైన్. సో నవేడేస్ ఈ సోషల్ మీడియా లేకపోతే టీవీ ఎలక్ట్రానిక్ మీడియా వచ్చింది కాబట్టి రేపు పినాకిని ఎక్స్ప్రెస్ రాదనగానే చీరాలంతా బస్సులో వచ్చేస్తారు మాకు. సో ఇట్ ఈస్ యువర్ డ్యూటీ ఆర్ కామన్ సెన్స్ పాయింట్ టు లుక్ ఇన్ టు ది రైల్వే టైం టేబుల్. సో ఎనీవే, అవర్ due to the change of times, our gentleman went there, but he missed the train. Immediately, he filed a case against the railways under Consumer Protection Act. Right? So please remember, State Commission held that the railways was liable for not informing him. This is another point you have to note. Not informing him. So at least if there is change of time, they should have sent a message. So at that time మెసేజెస్ ఉన్నాయా లేదా నాకు పెద్దగా తెలియదు. బట్ ఎనీవే దే షుడ్ హ్యావ్ ఇన్ఫార్మ్డ్. కానీ ఎంతమందికి ఇన్ఫార్మ్ చేస్తారు? ఏ పని అనేది ప్రాక్టికల్లీ నాట్ పాసిబుల్. సో దేర్ ఫోర్ స్టేట్ కమిషన్ హెల్డ్ దట్ దెర్ ఇస్ ఎ డెఫిషియన్సీ ఆన్ ది పార్ట్ ఆఫ్ ద రైల్వేస్, దే హ్యావ్ టు పే కాంపెన్సేషన్. సో అగ్రీడ్ బై దీస్ రైల్వేస్ పీపుల్, సో ఆన్ బిహాఫ్ ఆఫ్ రైల్వేస్ యూనియన్ ఆఫ్ ఇండియా, దే ఫైల్డ్ ఏ appeal before the Supreme Court. So the matter went to the National Commission. So National Commission held that opposite party, being an educated man, చూడండి ఇక్కడ మెత్తటి బాటా చెప్తూ కొట్టినట్టుంది, being an educated man, he was negligent in not enquiring the railways timings, new timings. తెలుసుకోవాలి కదండి, అది కూడా లేకపోతే ఎట్లా అన్న. సో నెగిటివ్ ఎగ్జాంపుల్. సో నో కేస్, దట్ మీన్స్ the railways need not pay any compensation. Now positive example, Union of India versus Kedarnath Jana and others, 1997. So Kedarnath Jana is also an advocate. So ఈయన కొడుకు బాగాల, హెల్త్ బాగలేదు. సో he wanted to take treatment in Bangalore. He is from Cuttack, right? He purchased a ticket from Cuttack to Bangalore for the treatment of his son, as I told you. Actually, he has to, that son was suffering with a disease, he has to go to Bangalore. Nimhanslo well. So, so he booked the ticket in Gauhati Express, right? Actually, it was supposed to come on the night of 9/6/1990 to Cuttack, but it was there was inordinate delay. Papa in railway station కి వచ్చారు, nobody knows the late, అప్పుడు 1990s కదా వచ్చారు. వచ్చిన తర్వాత పిల్లోడు he could not able to sit in the railway station. He has to take a lodge. కటక్లో లాడ్జ్లో తీసుకుని పిల్లోడిని పెట్టుకుని, the train was late by 10 hours. It started 9th night రావాల్సింది 10/6/1990, it came at 10 a.m. సో లేట్గా వచ్చింది, ఆటోమేటిక్గా బెంగళూరు వెళ్ళేటప్పటికో లేట్ అయిపోతుంది. అక్కడికి వచ్చినప్పటికే డాక్టర్ అపాయింట్మెంట్, ఎవ్రీథింగ్ వాజ్ డిలేడ్ అండ్ దిస్ మ్యాన్ వాజ్ సబ్జెక్టెడ్ టు సో మచ్ ఆఫ్ హెరాస్మెంట్, మెంటల్ agony, mental distress, emotional pain, so many things he has come across. చాలా ఇబ్బంది పడ్డాడు. సో దేర్ ఫోర్ he filed a case. So the advocate, the opposite party, suffered loss, inconvenience and so many expenses. Even at Bangalore also, he has to take a lodge. In the next day, Ramannaru. So much of expenses were there. Yes. So ikkada, the Supreme Court held that there is deficiency on the part of the railways, because railways failed to disclose the reason for the delay. At least platform ఏదైనా సరే, the train will be late for so many hours అని ఇప్పుడైతే చెప్తున్నారు, అప్పుడు చెప్పలేదు. కాబట్టి there is negligence or the deficiency of service on the part of the railways in not informing about the delay. So therefore, compensation of 5,000 or something was awarded, 500 and so. So anyway, compensation was awarded. So these two are train cases, particularly negative and positive examples. So whenever a question of this type comes, definitely you have to write the brief facts, you have to write the issue, you have to write the discussion, you have to write the case law, like just like Union of India versus Kedarnath Jana, so like that you have to write the cases and then only you have to give your conclusion. Yes, there is deficiency on the part of the railways. No, there is no deficiency on the part of the railways. You have to conclude. So with this, I am concluding. Thank you.